Indian News 24-hour.
Dhananjay MahapatraChadhas counsel, Anand Grover, argued that his client had been summoned by the trial court without there being any law to prosecute a retweet of an allegedly defamatory tweet by Kejriwal. TNN December 16, 2017, 0529 ISTRepresentative Im, New Delhi. The Supreme Court rejected on Friday AAP functionary Raghav Chadha's plea to wriggle out of trial in a 10 crore rupees defamation case filed by Finance Minister Arun Jaitley against him and 5 others, including Delhi CM Arvind Kejriwal, on the contention that there was no law making a retweet defamatory. Chadha's counsel, Anand Grover, argued that his client had been summoned by the trial court without there being any law to prosecute a retweet of an allegedly defamatory tweet by Kejriwal. There is no law and no ruling by any court in the world declaring that retweet of a tweet amounts to publication of defamatory material which could be liable for prosecution, Grover said. A bench of Chief Justice Deepak Misra and Justices A.M. Khanwilkar and D.Y. Chandrachud disagreed with Grover's contention. Justice Chandrachud said, take for example a tweet which is per se derogatory, abusive or contains graphic pornographic material. Can one who retweets such a tweet say he has only retweeted the material and is not the author of it and hence should not face prosecution? Can petitioner go on defaming people? Can one who retweets say he was completely oblivious to the contents of the tweet even if it is highly derogatory and pornographic? Justice Chandrachud asked. Grover said a retweet was an issue covered under the Information Technology Act, and since Section 66A was deleted by the Apex Court in the Shreya Singhal case, there was no provision in the IT Act to prosecute defamation. Section 499 and 500 of the Indian Penal Code cannot apply to an alleged offence under the Information Technology Act, he said. Contesting Grover's plea that defamation was not covered under the IT Act, senior advocate Mukul Rohatgi, appearing for Jaitley, said, does the petitioner mean that he can go on defaming people on Twitter and not face any prosecution? A field of law on defamation stands covered under Sections 499 and 500 of the IPC, and naturally it would apply to prosecute people who commit the offence of defamation. Jaitley's other counsel, Ranjit Kumar and Siddharth Luthra, said if Grover thought there was no judgment on whether a retweet of a tweet amounted to committing the same offence as had been done by the author of the tweet, then he should await the trial court's decision. This could be the first ruling on this issue. Citing the centre's recent decision to set up 12 special courts to fast-track trials against politicians facing criminal cases, Rohatgi said in a lighter vein, let the Supreme Court direct this defamation case be sent to one of the special courts so constituted. Both parties in the case are politicians. Jaitley had filed a criminal defamation case against Kejriwal and 5 other Aam Aadmi Party functionaries, Ashutosh Kumar Vishwas, Sanjay Singh, Raghav Chadha and Deepak Bajpai. In his complaint, Jaitley accused Kejriwal and the others of defaming him in a controversy regarding the Delhi and District Cricket Association, of which he was president from 2000 to 2013. He has sought 10 crore rupees in damages. Get latest news live updates on the go on your PC with News app. Download the Times of India News app for your device. Related WIRALGantechShow.com Kito Active Live Design Inspiration NASA data shows no reduction in crop fires. 2016 Worst Year Oberoi. ITC may bid for Taj Mansingh Stronger Indian Touch at Comic-Con.